those remarks then to launch our first panel. I'm really delighted that we'll be able to feature a number of prestigious Indigenous leaders in our first panel on Indigenous peoples' mobilization through international mechanisms. It features some new friends and some old friends, including going back as far as 2002 when I traveled to South Africa with Daniel Kobe for the World Summit on Sustainable Development. Driving around Joburg at night was a little bit intimidating, but we had a really exciting opportunity to contribute to the norm development of that event. And I'm pleased as well that this first panel, we're able to cover 3 very different geographical areas and to hear what leaders from Indigenous communities are doing to advance their rights in those landscapes. Allow me first to introduce each of our speakers before we begin to hear from them. Daniel Kobe, joining us from Kenya, is an esteemed founder and executive director of the Ogiek People's Development Program, where he has dedicated the past 20 years to empowering Indigenous communities. He has extensive experience in networking with Indigenous organizations globally in facilitating collaboration and advocacy on critical issues. He's been a representative of Indigenous peoples at the Convention on Biological Diversity, where he underscores the integration of traditional knowledge in biodiversity conservation efforts. As an expert in land policies affecting marginalized societies, he's played a crucial role in advancing the Ogiek community's land rights. His leadership was instrumental in achieving a landmark ruling by the African Court of Human and People's Rights in May 2017, which affirmed the Ogiek's ancestral land rights in the Mau Forest. There was a subsequent reparation judgment in June 2022, which further solidified this victory. He's also advocated for the rights of the Ogiek and other Indigenous peoples at the Permanent Forum on Indigenous Issues and at the Expert Mechanism on the Rights of Indigenous Peoples in Geneva. Speaking of that mechanism, our next speaker on my list is a member of that expert mechanism. Dr. Ojat Miro Odulu has a PhD in peace studies with a focus on minorities and Indigenous peoples from University of Bradford. He has over 20 years of hands-on experience as a local human rights defender in Ethiopia, researcher with Accord in South Africa, and Assistant General Secretary for International Affairs and Human Rights for the Lutheran World Federation in Geneva. He's a former minority fellow at the UN Office of the High Commissioner for Human Rights, and currently he works for the Danish Institute for Human Rights as the East Africa Regional Representative based in Addis Ababa, and he's also newly a member of the UN Expert Mechanism on the Rights of Indigenous Peoples representing Africa. Next, we have Dr. Hirak Jyoti Ray, who is from the Indigenous community, the Koch Rajbanshi of Assam, India. He was a PhD from the Center for International Politics, Organization and Disarmament at JNU in Delhi in India. And finally, we have Caden Watts, is from New Zealand-based Indigenous rights advocate from the Maori tribes of, and forgive my pronunciation, Ngati Tuaharetoa, Ngati Maniapoto, and Ngai Puhoi, and forgive me again for my pronunciation, with a focus on climate change, health, human rights, and Indigenous sovereignty. He's an experienced policy advocate and campaigner both domestically and internationally through the United Nations Human Rights Working Group and Indigenous Peoples Forum on Climate Change. He currently serves as the Climate Change Implementation Lead for the New Zealand Ministry of Health, adapting the health system and advancing public health interventions to address the impacts of climate change. So I think you'll agree with me that we have a very prestigious panel. They're going to bring us a rich understanding of leadership of Indigenous peoples across a number of spaces and thematic areas. I'm going to invite first Caden Watts to speak. Very generously, he's joining us from New Zealand, which is 13 hours ahead. So I've adjusted the agenda to enable him to participate before he falls asleep. So the floor is yours. You're welcome.
And that was very generous that you did that, Corinne. Thank you very much. Kia ora koutou. Nice to be with you all today, and thank you very much for the invitation to contribute to a really meaningful discussion today. I'm really excited to share a little bit about what we're doing here down in the Pacific. I'm just going to share my screen, and then we can jump into it. Awesome. Well, again, thank you very much for having me today. I'm really excited about the opportunity to talk a little bit about what we're doing down here in the Pacific. In the interest of time, although I would love to share a whole bunch of examples about what's happening here for Indigenous peoples and Pacific peoples as it relates to climate change and Indigenous approaches to climate change. In the interest of time, I'll probably just focus on New Zealand today and our Indigenous peoples of New Zealand to give a bit of a snapshot on what's happening in the Pacific. To do that, I want to provide a bit of context about what the relationship looks like between Indigenous peoples and the environment down here in Aotearoa, New Zealand. Before moving into some of the solutions that we've started to action that challenge Western frameworks and Western law, and to mold it and to change it in a way that actually advocates for the rights of Indigenous peoples as it relates to the environment. So thank you for having me. Can't fight. But just to introduce myself and to give a bit more context as to who I am, e noho ana ki Aotearoa hau, ko whanganui te awa, ko Ruapihu te manga, huiri tēnei no Ngāti Tūwharito, Ngāti Maniapoto, Ngāi Tūhui Huki, no Watts tōku whānau, ko Caden Watts tōku ingoa. My name is Caden, and I'm from the tribes of Ngāti Maniapoto, Ngāti Tūwharito, and Tūhui. And probably quite relevant to this conversation today, I'm the climate change lead, as Corinne said, for the New Zealand Ministry of Health. So focusing on public health interventions to the climate crisis. How can we adapt the health system, but also protect the health of our populations here in Aotearoa, New Zealand. So when I introduced myself to you before, I introduced myself in our native language. I introduced myself in Te Reo Māori. And the framework that you're looking at there on the right is a very uniform standard way that we would introduce ourselves as Indigenous peoples, not just to each other as Indigenous peoples, but all around the country as well, Māori and non-Māori alike. And so we start with the lands that we come from. So I talked about being from Aotearoa. I told you the mountain that I belong to, the river that I belong to. I move down a layer and I start to talk about the tribes that I belong to and my broader community before moving into my family unit and then finally me. It's important that we do this because who I am and who I bring into the room is more than just me. It's my family, it's the tribes I come from, my communities, and indeed the lands that I come from. If you were to walk around New Zealand and introduce yourself to an Indigenous person, after they ask you for your name, the next question they're going to ask you is, where are you from? And so knowing these things and understanding your connection to them actually builds into this picture of who you are. It's how we relate to each other. It's how we understand each other's context. And that builds into our Māori or Indigenous model of health here in New Zealand. So this is a framework that was developed by a treasure to our people, Sir Mason Jury, in 1984. And it's called Te Whare Tapawhā. And so Te Whare Tapawhā is a Māori model of health that's actually based around the Māori meeting house, very similar to the picture that you saw at the beginning of my slides. And it's based around 5 different facets that all contribute to a holistic picture of health. Our mental and emotional, our family and our social, the land that we come from, our physical health, and our spiritual health. If one of these things isn't being serviced, then our holistic idea of health is not being serviced. So when one of these walls is not being met, then our whole holistic being of health is not being met. So we have to cater to all these things. And why I bring this up is because there's a really important facet as part of that, and it's the land. So if the land is not being serviced, if the land is not being serviced that we come from, then we as people are also not healthy as well. And there's a really famous proverb or saying that we say here in Aotearoa to each other, a whakatauki, ko au te awa, ko te awa ko au. I am the river is me. And that takes us back to that framework. My energy and my health is not indistinguishable from the environment that I come from. And so I have to look after that. The second that land that I come from, those mountains, those rivers, and indeed the communities that sit on them are not healthy, I as an individual am not healthy as well. And so climate change actually fits into this idea, this connection between Indigenous peoples and land really strongly, because it actually severs our relationship with the land. It acts as a barrier to Indigenous peoples being able to access a holistic idea of health. And so, given my background in public health, I like to think of climate change as a health issue because climate change directly challenges our ability to live healthy lives. That process of climate change and health, the two are inextricably linked. And I often go to this quote here from The Lancet. Climate change is the greatest global health threat facing the world in the 21st century, but it is also the greatest opportunity to redefine the social and environmental determinants of health. Yes, it is the greatest global health threat that we're facing, but there's a lot of opportunity to rethink the way that we approach climate change, to rethink our relationship with the environment. And I'll make the argument later on in this presentation that I don't think we have to look too far to understand what that looks like. And that'll be contextual to all the different regions that we all come from in this room. So to break down what those health impacts of climate change look like, I usually break it down into four different ways: direct impacts, indirect impacts, deferred or diffused, so mental health, and then conflict/migration. To give a better picture and understanding of what that looks like, I often refer to the recent extreme weather event that we had here in Aotearoa, New Zealand in 2023, Cyclone Gabriel. Um, the different areas that I just discussed now, our direct or indirect impacts, they actually bundle quite neatly into what sort of impacts Cyclone Gabriel had on the health of populations and the health of our environment here in Aotearoa. Immediate and direct impacts look like injuries and loss of life, loss of housing and community hubs, usually coming from extreme weather events or large scale, causing large scale loss for communities. That can lead to food insecurity as well, damaging crops, livestock, and infrastructure. And then the indirect impacts usually come as a flow-on effect from those direct impacts. So we have increased vulnerability to illness due to contaminated waterways or weather influence. Infrastructure damage impacts transport. It impacts housing as well and the ability to secure housing, our income sources, and persisting economic damage and insecurity also impacts our communities as well as their ability to access services and options to adapt in the future. For deferred and diffused, there are widespread mental health impacts that are associated with repeated extreme weather events. There was a really interesting study that we commissioned out of the Ministry of Health to look at the impacts on communities, particularly their mental health, in the follow-up to Cyclone Gabriel. And one of the things that we saw most was sleep disruption, anxiety, depression, and the follow-on from Cyclone Gabriel. We had some participants respond and say when they heard rain pitter-pattering on the top of their roof, that was no longer a source of comfort for them. That was actually a source of anxiety because they didn't know if that meant they were going to have to evacuate again. Culture and trauma and sadness is also a flow-on effect for Indigenous peoples when it comes to the health impacts of climate change as well. I touched on it briefly earlier, but the loss of land and land degradation actually has increased impacts for Indigenous peoples and indeed Māori when it comes to the impacts of climate change. Not being able to access your ancestral houses, not being able to access your ancestral land or your culturally significant sites actually has a tremendous effect on Indigenous people's health and well-being. And those impacts don't just sit with you, that sits with your wider community. And I use a lot of our Indigenous language throughout this presentation, but I'll translate. It impacts on our wider families and our wider social circles as well. And then one that we don't necessarily see as much here in Aotearoa at the moment is conflict. But we know as resources and access to land becomes more and more scarce, the conflict to secure that land will become more and more extreme. But one we are seeing in the Pacific, relevant to all of the Pacific, is migration. So there's already mass displacement that occurs to communities and the follow-up to extreme weather events. But as the incremental impacts of climate change become more and more extreme, we're going to see our brothers and sisters all around the Pacific have to migrate to different countries. And that will likely be New Zealand and Australia. And that is the role that New Zealand and Australia should be playing in the Pacific. We should be opening up our doors to our Pacific family to come and resettle here. But we have to be aware that we do operate with very stretched systems in New Zealand, a very stretched health system and other central services that don't actually accommodate for the populations that we have now. So while this is something that we should be engaging in, we have to be prepared to adapt our systems to actually accommodate for what that migration might look like. And while those impacts will impact everybody in New Zealand and indeed all over the world where that happens, these impacts have exacerbated effects on Indigenous peoples. Loss of land and degradation impacts cultural health and connection. If I can't access my land and I can't access my communities, I actually start to lose a lot of the ties that I have to my culture. I can't access my Indigenous knowledge systems because I can't access the people who hold that knowledge. I can't access my language because I'm not there to communicate with the people who hold that language. I don't know the context of my ancestral lands because I'm not able to access those lands anymore. And not being able to access those things and build up your cultural health will impact your wider holistic idea of health as well. There are already existing systemic barriers, and climate change is just going to reinforce and exacerbate those existing barriers even further. Same with socioeconomic inequities as well. Furthermore, limiting the opportunities that Indigenous peoples have to adapt and limit our resilience options. And so those health inequities grow, existing disease, illness, chronic conditions are exacerbated. And like I said earlier, the cultural knowledge is impacted as well. And just to continue that point further, the way that Indigenous peoples operate in here, here in Aotearoa, our day-to-day way of life and the way that we engage in our culture is directly impacted and threatened by climate change. And so that means the signs that we used to look to in the environment are no longer as relevant and are constantly changing. So we don't actually know how to look after and care, be hospitable for our environment and the way that we've done for hundreds and thousands of years. And those changes are happening really, really quickly. The culturally significant places that we come from are also at risk. We're currently entertaining conversations all across the country on managed retreat. And that is a really big question for Indigenous peoples, because what does that mean for all of your histories, your culture that you built on those lands that you come from? And of course, the ability to pass down that information is impacted by climate change as well, as we start to lose that more and more. And so the argument that I'm making here is that this process of colonization and the impacts that we've seen because of colonization actually one-to-one correlate with the process of colonization as well. And so in my research, in my belief, the process of colonization comes one-to-one with the impacts and intensity of climate change. They follow the same process and their drivers are synonymous. And so it starts with colonial settlement before moving into the assimilation of Indigenous peoples and that settled land. Before then, exploiting the resources of that land, and then reinforcing structures of inequity that prevent the Indigenous peoples who looked after that land to continue practicing their knowledge systems. And then eventually that exploitation and those systemic barriers for Indigenous peoples to accessing their land eventually lead to climate breakdown. And so if we were to place that on a timeline, climate change is just the end result of that colonial process. It's just the continued isolation and formation of barriers to Indigenous peoples being able to access their land, knowledge systems, ancestral, culturally significant sites, and so on. And so we're not going to find the answers to those issues and the process and the drivers that actually lead to their formation. So we can't look to colonization, capitalism, and exploitation to hold the answers to overcoming those issues like climate change and inequity for vulnerable populations. But what we can do instead is look to re-indigenizing our knowledge systems and decolonizing the way that we think, and looking to those processes to lead the response in our different geographical areas to understand what a response to climate change that is environment first, people first actually looks like. So rethinking the way we approach these issues, founded in Indigenous thought and practice, and that can provide the solutions with Indigenous-led actions already providing these solutions in Aotearoa. And one key one that I think a lot of us may actually be familiar with already is this idea of legal personhood. And so I wanted to bring up this point because this really speaks to that relationship that Indigenous peoples have between themselves and their communities and the environment. So in 2014, a world first initiative was achieved by the Tuhoe tribe, the tribe that I come from, where legal personhood was granted to the Te Urewera rainforest. And this shifted the legal status of the rainforest from a national park to a legal person with all the same rights, responsibilities, and duties. And so what does that actually mean? Well, for a legal person to be created under law, they have to fulfill a purpose. And so this is really important. The purpose of the Te Urewera Act 2014, the bill that went through Parliament to actually make the Te Urewera rainforest a legal person, was to protect the status for Te Urewera for its intrinsic worth, its distinctive natural and cultural values, the integrity of those values, and for its national importance. And this is really important because this goes against the grain of what we used to when we treat the environment here in Aotearoa, which was very much something separate from ourselves. But this quote here, and another quote that I'll bring up in the next slide, actually points to the importance of the values had that the Indigenous peoples of that land have for the Te Urewera rainforest and the importance of honoring those values for the sake of its national importance. And this concept is not a new concept either. This is a well-accepted concept in common law jurisdictions. If you're familiar with company law, this is something that companies do as well. But the existing legislation was just used and molded to fit the values of Indigenous peoples and land protectors. And
Kaden,
this is
sorry, Kaden, we've come to time. If you can try to come to a conclusion.
Oh yeah, sounds good. Sounds good. I'll skip over this one because I think we have made that point already. And so why did we take this approach? Well, for a land ownership model to protect the interests of Māori, it has to recognize Māori customs. And this is something that hasn't actually been done in Western and colonial law before here in New Zealand. There was a case that I won't jump into for the sake of time back in 2019 that pointed to tikanga Māori being, or Māori custom and Indigenous law, being recognised in Western and colonial law. And so groundbreaking approaches like this actually help us rethink the way we use the current systems that we have to actually advocate for the rights and the interests of Indigenous peoples. Legally owning land also didn't exist in the Māori world before colonization. And so this is an entirely new concept that actually needs to be broken down and built back up in a way that works for Indigenous peoples. And this example is a positive example of that. And through colonization and climate change, that rainforest had been harmed, even causing closure to the public at one point. This gives back control to Māori, to the Indigenous people of that specific land, to protect its best interests. And that 2014 bill that granted legal personhood to Te Urewera rainforest has actually led to a whole bunch of other initiatives as well that has allowed for different natural features to also gain the same rights. Whanganui River and Taranaki Maunga as two examples. But we have examples from Canada as well. We have examples from Bangladesh, India, examples all around the world following that approach. And so I hope that gives, in this brief conversation today, I hope that gives a little bit more context to this framework here and the way that Indigenous peoples here in Aotearoa, but indeed the Pacific, actually approach their relationship with the environment, and why we're rethinking the way that we engage with Western colonial law to actually advocate for the rights of Indigenous peoples in a way that works for us and works for our environments. Ngā mihi kia koutou mō whakarongo. Thank you for listening. And I will stop it there.
So much, Kaden. There's obviously a lot that we can dig into, hopefully a bit more in the discussion, but it was a great start. I think it really set the scene for our topic. today, and interesting the role of Indigenous peoples in pushing us to think more broadly about the social and environmental impacts related to health. It reminds me of the way that they challenge biomedical approaches to health as well, prior to this discussion now on climate and environment. Thank you so much for that. I'd like to invite our next speaker, Daniel Kobe, to take the floor from the Get People's Development Program. Daniel, you have the floor.
Thank you, Corinne, and thanks for reminding me of our traveling job. And the way you are one of the best drivers ever. And really, it's very, very interesting. So I don't have a PowerPoint, but I have a story to tell. And because of the noises where I am, allow me to use earphones. The story is more or less the same what my brother was talking about, but I don't want to repeat that, but to tell you a story about the struggle of Ogier community in Kenya. Ogier community is an indigenous community in Kenya. We are about 52,000 people. We are within more than 6 counties in Kenya. And our struggle goes around land rights and to be recognized as an indigenous community in Kenya. And this kind of a struggle didn't happen yesterday. It has taken more than half of some of us lives. And it is one issue whereby a community is fighting with the government. And one key issue here is about environment and ancestral land of the Ogier community. Ogier means caretakers of flora and fauna. And as a community, we have seen and gone ups and down for the sake of having our land rights. The situation amongst the Ogier community keep on changing or metamorphosizing in a way which makes the people feel sometimes less Kenyans. Why do they feel sometimes less Kenyans? Is when you are not recognized or given equal opportunities like other Kenyans. So as a community, we found ourselves struggling for our land rights in Mau Forest Complex. And in this case, the government of Kenya feels this is the land for a protected area or for environmental restorations. While we see it as our land, as ancestral land, where we were born and brought up, where our generation have been. So as we continued struggling, we found our way and say, now the next thing we do is to go to court. So from 1997 all the way, we started going to court here in Kenya. Later on, we realized we were not getting justice. So we ended up going to the African Commission, which we stayed there from 2009 to 2012. From 2012 all the way, we went to the African Court, seeking for justice. As we continued doing that, it was a hard thing to bring together the community. So we created what we call a feedback mechanism, whereby everything we got from our lawyers, which some of them were from UK, and is that we must relay the information back to the community. So that kept the momentum of the community to struggle for their land rights. So we stayed there. In 2014, we went for a hearing in Addis Ababa for a hearing. And later on, we had 2 of our community members being witnesses and 1 expert witness. In 2017, we got a favorable judgment where Ogier were given to own and protect and have their land rights in Mau. But the court withhold what we call reparation. In 2022, 23rd June 2022, we got a favorable judgment again, allowing Ogier their restitution, customary land rights, and also some compensation. As we were doing all these things, our community were facing threats, especially as the leaders. As we were fighting, we also having threats within and without, and sometimes even within our own community where we have functions. But we were able to mitigate this using many, many other ways by bringing up the Ogiek Council of Elders and bringing up the women and the youths. In fact, the youths came in at a later stage when they realized now we could use media as a way of protecting our land rights. Media played a critical role in ensuring the Ogiek issues were heard not only in Kenya, but globally. We also work with other human rights institutions globally, and we started working also within the country, trying to understand that we also started doing rehabilitation within Mau Forest Complex using traditional methods, whereby we wanted trees planted there, must be trees from there, not imported or artificial trees. And we have planted over 1 million indigenous trees in Mau from 2014, 2016, to prove to the Kenyan government that given a chance or given a gift to have control of their land and territories, they are able to protect this particular ecosystem. Unfortunately, most recently, there was a big wave, what we call carbon credit, carbon market, which somehow it is not fully disclosed, or there are no proper disclosures about what is the role of this carbon market, who is buying, who is selling, because this is our ancestral land and we are not ready for that. Because us as an Ogiek community, our role has been, let us have our customary titles, which has also been supported by the National Land Commission, which have confirmed that Mau Forest belongs to the Ogiek community. But our government, because of poor political goodwill, till now, there have been slow implementation of the judgments. But because we have had that, they have even formed commissions, task forces to ensure this implementation. But as I'm talking, nothing has happened. We have even tried talking to high commissioners in Kenya from various countries, including UK, Denmark, to speak to the Kenyan government to be able to allow Ogiek rights to their land, but it has not worked well. We have also had many other for solidarity efforts, petitions, everybody talking about the Ogiek as an indigenous community to be given, because we want to protect our culture. We have already started even a cultural center where we have our own museum, we have our own work, where people come and see that we still maintain our cultural issues, even developing herbal medicine, herbariums, to ensure that we transfer knowledge to the younger generation. So as I'm speaking today, we as a Ogiek community have not received our rights to our land. And we call upon those who are listening and even beyond to give and speak to Kenyan government, if you have a ear to them, that they should give Ogiek their land rights and avoid these kind of delay tactics, which has made Ogiek to suffer over generation. We have continued receiving evictions until recently in 2023, when we got the latest eviction, where over 700 Ogiek are now homeless. And there is we had to get well-wishers to get and support them. But as I conclude, the story about Ogiek is so wide. I know Corinne can bear witness from those years to date, still speaking the same language, struggling for the rights of the Ogiek community. Thank you very much.
Thank you so much, Daniel, for sharing the story of the Ogiek community, which is really an extraordinary testament to resilience and determination of the community. And you've shown us that they've just deployed so many creative legal strategies, just to try and shift the Kenyan government on this. So thank you for sharing that story with us today. The next speaker I have is Dr. Ojadmiro Ojulu. Oja, would you like to take the floor?
Yes, hello and good afternoon, good morning, everyone. I have a PowerPoint presentation. Let me share that one with you. I hope you can see my screen now.
Yes, please go ahead.
Okay, thank you. Yes, as introduction, thank you, Corinne, for the elaborate introduction. Just to mention that I also belong to indigenous community called Anywa, in southwest Ethiopia in a region called Gambela. And actually, it was in that capacity that I first met Corinne in Geneva while I was on advocacy mission to Geneva. So really great to see you again. But here, what I would be doing is to really briefly discuss and talk about some of the ways in which Indigenous human rights defenders are using emerging global norms, policy frameworks, and forums on business and human rights to protect and promote their rights. Currently, there is an interest, in the business and human rights issues. From the UN Global Compact and then the United Nations Guiding Principles on business and human rights, and could be aware of the EU Corporate Sustainability Due Diligence Directive, and of course, other policy frameworks. So I would be discussing how Indigenous activists in the Africa region are working to incorporate and mainstream, the provisions of the United Nations Declaration on the Rights of Indigenous People in those policy frameworks, whether those at early stage that are being drafted or in the implementation of the policies that are in place. In a way, I think we know that the impact of business on human rights in general, I think that is clear. But here I want to highlight that Indigenous peoples are actually impacted in a peculiar way by business activities. Historically, we know that businesses, whether in the extractive industry or other sectors have impacted human rights of different communities. But when it comes to Indigenous people, because businesses do not operate in vacuum, they operate under national laws and then, national economic systems and policies that are sometimes designed, at best without consideration of the rights of Indigenous people, and at worst, some of those policies are designed with deliberate intention to systematically dispossess Indigenous people from their lands, territories, and resources. So in such a way, business activities have this direct and disproportionate impact on the rights of Indigenous peoples in different, it could be extractive industries, as mentioned, in larger scale land investments. I did my research on larger scale land investments and its impacts on Indigenous communities, and actually see that in some places governments put in place policies to target Indigenous areas to get control over their lands and to dispossess and to displace them from their land. So businesses are actually used also by governments as a way to disempower Indigenous communities and take control of their lands and resources. And recently, with the increasing international interest on critical energy transition minerals, I think this is also an area of concern for Indigenous people's rights. Just as the summary, business operations have impact on several rights of Indigenous peoples. Just to highlight some of those, as per the UN Declaration on the Rights of Indigenous People, the right to self-determination, which according to Article 3 of the UNDRIP, is the right to freely determine their political status and to pursue their economic, social, and cultural developments. This is very important issues for Indigenous people. It's not just about economic and cultural rights, but it's also really a political right that is being impacted and affected by business operations in Indigenous areas and territories. And of course, under the UNDRIP, indigenous peoples have the right to free, prior, and informed consent. And then, of course, the protection of their traditional lands, territories, and resources. Under these rights, there are several rights that are impacted by business operations in indigenous areas and territories. So when it comes to UN guiding principles on business and human rights, actually under the three pillars of the UNGP, it actually talks about indigenous rights. You know, the first pillar with regard to states' duty to protect human rights. It states that the state should provide effective guidance to businesses on how to integrate and protect indigenous people's rights. And then under Pillar 2, you know, with regard to corporate responsibility to respect human rights, it also expects businesses to respect and take into account indigenous people's rights in their entire operations. And then on Pillar 3, also with regard to access to remedy, it talks about the states providing appropriate measure to ensure that indigenous peoples have access to remedy when their rights are abused and violated in business operations. So just to come to Africa, the business and human rights framework within the region, there have been policy framework, you know, from the Charter itself, the African Charter on Human and People's Rights. There are favorable conditions under the Charter for the protection and promotion of indigenous people's rights in business operations, because the Charter recognizes the right to economic, social, and cultural development of the African people, and also it codifies the right to development, you know, as a binding norm, which is quite unique, and this is, I think, the only regional mechanism that codified the right to development as a binding norm under its framework. And then the Commission has actually established a subsidiary body, you know, on extractive industries and environment. And in 2023, the Commission passed a resolution on business and human rights in Africa, basically creating a working group to draft a regional legally binding instrument on business and human rights. And then since 2022, the Africa Union has been holding Africa Regional Forum on business and human rights. So indigenous human rights defenders from the region have been, you know, employing and using these emerging opportunities, norms, to advocate for their rights, and also to mainstream the provisions of the UN Declaration on the Rights of Indigenous Peoples in the emerging frameworks in the region. And most important is really the work around advocacy towards inclusion of indigenous people's rights in national action plans on business and human rights. This is one of the thematic areas where indigenous human rights defenders have been advocating for during the regional forums on business and human rights. The picture you see is human rights defenders, indigenous human rights defenders in Nairobi during the third African Forum on business and human rights. Just to see that in some of the national action plans on business and human rights that have been developed so far, for instance, Kenya is the first country to adopt a national action plan on business and human rights. And there, you know, issues of indigenous rights, especially in relation to land and resources, has been included in the Kenyan National Action Plan. And also in Uganda, which is the second country in Africa to develop a national action plan, they've also included indigenous people's rights, especially in relation to free, prior, and informed consent. And some of the countries that are developing national action plan, for example, in Ethiopia, indigenous people's organization are included as part of the technical committee to advise and give inputs to the development process of the National Action Plan. And I think those conversations, those advocacy efforts at regional level are having impact at the national level to consider the issues of indigenous peoples in the development of national action plans on business and human rights. So just to conclude, I think it's very important that indigenous rights are incorporated in the emerging policies regionally, and this is what indigenous human rights defenders have really been advocating for on the regional forums, and then also to move at the national level to ensure that discussions at the regional level are discussed also at the national level, especially during the development of National Action Plan on Business and Human Rights. And then enhancement of stakeholders' engagement. I think National Action Plan development is one thing, but to ensure that the voices of indigenous peoples are included, even at the stage where national baseline assessments are conducted and human rights impact assessments are conducted, that the issues of indigenous peoples feature in those assessments documents and at this stage of consultations and national baseline assessments. And of course, establishing a grievance mechanisms as Daniel really mentioned. In the case of the Ogiek community, access to remedy is a very important pillar within the UNGP, and how do we ensure that the situation and issues of indigenous peoples are also considered and taken into account when such mechanisms are developed. And finally, the capacity building, the need for more capacity building and protection for indigenous peoples, human rights defenders in this process. I think this is also a very important work that needs to be continued. So I think for the sake of time, I stop here. And thank you very much. Back to you, Corinne.
Thank you so much, Ojat, for giving us an understanding of what looks like very exciting and progressive norm development at the regional level in Africa. Obviously, contrasted with Daniel's plea for a remedy, as you say, there's obviously a two-speed process there, but it's exciting to see where there is progress and how people have an opportunity to participate in that. And next, our final speaker is Dr. Hirab Jyoti Ray.
Good morning, everyone. Although it is already evening in India and it's past 4 p.m., but since I'm addressing to the chair and people in different countries, so I would stick to saying good morning. I don't have a PPT. Anyway, coming to my paper, I'm going to present a paper titled World Bank's Programs on Indigenous Peoples in India, Responsiveness of Inspection Panel to Indigenous Complaints. Largely aims to highlight on the 4 registered cases filed by various indigenous communities of India. India was an original participant of the Bretton Woods Conference of 1944. Since the inception of the World Bank, India has remained a member country. Over the decades, it has borrowed loans for a number of development projects. During India's early years of engagement, there were projects which had an impact on indigenous peoples, but at that time, there were no operation policies of the bank to address the said issue. The bank before the 1980s had hardly undertaken any initiative for addressing the issue of indigenous peoples. The establishment of the inspection panel in 1993 was an important shift in the World Bank as an international organization. Criticisms of a particular project from India, which is Sardar Sarovar Dam project, both inside as well as outside the bank, paved the way for the creation of such a unique in-house institution. Subsequently, through the cases filed by affected people, especially indigenous peoples, the inspection panel in some way or the other is shaping or reshaping the bank's discourse on indigenous peoples. Indigenous peoples around the world became significant actors who can now question the non-compliance of the bank's safeguard policies. Inspection panel is an example which shows that there was an urgent requirement for reform in the international organization as well as for the functioning of global governance. Important to note here is that the panel is not permitted to accept or receive requests for inspection that are submitted after the loan that is financing the project has closed. This is in accordance with the resolution that constituted the panel. I will now discuss the few cases related to India. The first case is NTPC Power Generation Project. In 1993, the board of the World Bank approved the loan of 400 US million for the project. Fly ash from the coal, which used to run the plant, was deposited in ash dikes. This was considered as a significant issue. Despite the fact that NTPC had already owned the majority of the land necessary for the ash dikes before 1993, more fresh hectares had to be procured for the additional ash dikes. Therefore, the location chosen necessitated the forcible relocation or involuntary displacement of numerous indigenous families. Thus, the bank approved financing for Singraoli's coal-fired power plant expansion. The request had been registered by the panel on 2nd May 1997. The requester of the case claimed that the bank violated a number of its own policies, such as Indigenous Peoples Policies Operational Directive 4.20. The 1993 loan also contained an environmental action plan, which was intended to enhance environmental management as well as monitoring apart from the expansion of both power plants and the ash dikes. In addition, the loan created a plan to handle unresolved resettlement and rehabilitation concerns and increase NTPC's resettlement and rehabilitation capabilities. In order to resolve the issue, a framework was prepared under which two different kinds of stages were established. Stage 1 focused on the issue of rehabilitation and resettlement for earlier displacement, while stage 2 specifically looked at the issue of displacement that occurred of the new loan. Displacement had adverse impact on the lives and livelihood of the people of Singrauli. It destroyed the agricultural productivity of land, thereby affecting tribal communities such as Baigas, Dharkas, Gond, Kol, Panikas, who lived in the Singrauli region. The vulnerable groups Baigas, Dharkas, Gond lost their traditional livelihood because of the deforestation. These in turn destroyed the unique cultural identities. For instance, traditional occupation of the Dharkars was bamboo work, which disappeared as it became inaccessible for Dharkars to use the existing bamboo grooves. However, bank management rejected the claim of the requesters that the project violated Indigenous Peoples Policy 4.20 of the bank. The argument given by the bank management was that OD 4.20 differentiated ethnicity from indigeneity. The management highlighted that all vulnerable groups could not be recognized as indigenous because no indigenous peoples were found or impacted by new investment in Rihan 2 and Vindhyachal 2 of the project. According to socioeconomic studies conducted prior to the project appraisal, management believed that there was no necessity for special consideration. The second case, which I am going to discuss, is the Eco Development Project, also known as Nagarhole National Park. The primary aim of the Eco Development Project was to assist the biodiversity conservation. It is said to have one of the greatest animal biomass productivity rates in the entire globe. The project also intended to involve the indigenous peoples of the park in the planning and implementation process. There are 32 scheduled tribes which is a legally recognized indigenous peoples by the government of India in the project area. These tribes relied on forest ecosystems for their way of living subsistence. Their society and culture are intimately connected to their ecology too. They had different occupations such as Jenu Kurbas, who are honey gatherers, while Yarwaras, who are swamp and paddy cultivators, and tribe like Haki Piki are the bird trappers traditionally. The bank highlighted that there were no tribal, especially in the core area of eco development project. Despite that, the bank eventually acknowledged that roughly 7,000 tribals were residing in the project's core area. Tribal people argued that the bank had failed to comply with its own indigenous peoples policy of that time, known as OD 4.20. Moreover, indigenous peoples' legal status was not effectively studied, and also no legal framework was made in order to uphold the rights of tribal peoples. In its background, inspection panel received a request from Nagarhole Butaka to Janara Hakusthapana Samiti on 3rd April 1998. On May 5, 1998, the bank management, as a response to the request made by the same organization, claimed that the management and had complied with it with all the related policies and procedures. Management pointed that it is, and I quote, well understood that it would be controversial project largely because of divergent views coming from those with interests in biodiversity and those with interest in expanding people's access to resource. The management further observed that although the project attempted to resolve the issue could not be simply solved because the solutions were quite complicated. Informed consultation, which is the principle of World Bank's indigenous policy, in this case, only took place with the NGOs. According to the requesters in the name of informed consultation, the bank only provided staff appraisal report to the tribals of the park. Despite tribal communities' request, the bank never translated staff appraisal report document into local language, which is Kannada. And this is also the violation of World Bank's own policy that it has to be that World Bank required to disclose its information in the local languages. However, no informed consultation also took place in the appraisal stage. Rather, the bank management felt that rather than applying OD 4.20 in the appraisal stage, it proposed that through thorough consultation would take place in the implementation phase. The panel concluded that the fundamental assumptions that underpin the project's design phase at the Nagarhole site were faulty, and as a result, there was feasible of serious risk of serious harm. Therefore, it recommended the board of executive directors to approve the investigation. Subsequently, the board denied to authorize the investigation. And the third case is the coal sector environmental and social mitigation project and coal sector rehabilitation project. Same like other cases, a request for inspection pertaining to this project was submitted to the panel on June 21, 2001. Ms. Bina Stennis, under the banner of a local NGO called Chota Nagpur Adivasi Seva Samiti, filed the complaint to the inspection panel. The Chota Nagpur Adivasi Seva Samiti represented local people, primarily Adivasi communities. Adivasi means Adivasi, which means original inhabitants of the land. Communities resided at the East Parej coal mines of Hazaribagh district of Jharkhand. The most disastrous effect of the project were experienced at Parej East, one of the 25 mines that obtained funding from the bank. The panel registered the case on 22nd June 2001. The panel subsequently requested a response from the management, which it received on July 20 of the same year. The management insisted that it had complied with environmental and social policies of the bank, whereas its claim stood in complete contrast to the requester's allegation of the bank's violation of policies. However, after the panel's visit to the project area and response of the bank management, the inspection panel recommended an inspection. The board approved the recommendation for inspection in September 2021. However, no investigation took place till date. The final case is the Rural Water Supply and Sanitation Project for low-income states. The objective of project was to develop piped water supply as well as sanitation services in 4 states of India with low incomes like Jharkhand, which is a tribal state. The inspection panel for the inspection of this project had received 2 requests. The first request was on September 21, 2018, and the second request was on December 12 of the same year. On 5th of November 2018 and 18th December 2018, the panel respectively registered the requests. The panel was considering them jointly since they presented issues that were similar and related to the same project. It was noticed that 104 members of the Santhal tribe from a village in the Indian state of Jharkhand made the initial request. Santhal community objected to the project's location and claimed that it was built on community's land, which was significant to them both historically and culturally. The project was also encroaching the cremation and burial lands of Santhal tribe. They alleged that economic effects such as increased cost for drinking water and a sharp reduction in access to community resources would occur as a result of the project. In the second request, we learned that 130 members of the Ho tribe and Santal tribe from another Jharkhand's village filed the complaint. The requesters argued that the location of the project was significant martyrdom site for Santal community. Additionally, they asserted that being forced to pay for water which is currently free would cause them to become impoverished. From the cases discussed above, we can draw that although the inspection panel's potential influence is significant, it was purposefully given a limited mandate to monitor the bank's compliance with its own operational policies or other safeguard policies, and is subject to the board of executive directors monitoring and veto. Furthermore, the inspection panel's effectiveness is constrained by its failure to put the recommended remedial measures into effect and practice. For instance, in the case of eco-development project, it's clear. It is evident from the above cases that the board denied investigation of a complaint in most other cases like NTPC cases and eco-development project. Most importantly, the inspection panel is unable to offer any redress to complainants. The panel is also not permitted to make recommendations that are legally enforceable. Instead, it may only offer findings that may or may not contain meaningful and significant observations. The inspection panel just provides guidance to the board of executive directors, which decides how to proceed. The inspection scholars also draw attention to the fact that the absence of participation or underrepresentation of developing countries in the institutional structure of the panel also places restrictions on the panel's ability to achieve its participative goals. Thus, the creation of the panel, though mark an important development in the history of international financial institutions, its limited mandate, overdependence on board of executive directors, limited knowledge of experience regarding the project areas, lack of indigenous experts, non-involvement of local expertise, etc., makes it a body that hardly produced any significant change in the name of bank projects. The panel's mandate of not registering cases where loan disbursements as well as loan agreements are over highlights a structural limitation which puts the entire process of accountability under question. Besides, the on-paper provisions of the inspection panel of being a citizen-driven accountability mechanism institution is itself defied when dominance of the executive directors is made visible. Thank you.
Thank you so much, Hirok. I think it was really valuable to look at that granular level of those cases and to see, well, again, like the OGEC, that it is very inspiring to see how well Indigenous peoples have mobilized to use the remedies that are available. Unfortunately, as you've illustrated, they've not been very effective in implementation. Finally, invite our audience to thank once more of our speakers. We appreciate your time, and it's been a fantastic opening panel and really set the tone for the rest of the day. So we invite you to continue to monitor online as long as you wish, and we'll be back for our next panel in about 15 minutes. So thank you so much.
Thank you very much. Lovely to be with you.
Thank you.
Thank you. It's nice to be with you.
Thank you.